Court does call the case, People versus Jacqueline Murray.
Helps for the people.
Edward Lucas for Jacqueline Murray, who is approaching.
Your name?
Jacqueline Murray?
I knew that.
I know.
Okay.
Your Honor, this case has been around for a little bit. There's been a lot of moving parts, and I don't think we've gotten to a resolution yet. So I've been asking for an adjournment. Short of that, I'd just be asking for a final settlement conference.
Well, why don't I set it for a final settlement conference? Because we've had like a lot of adjournments.
Okay,
That work?
Do you return?
Sure. Apparently that's a no.
Welcome back to another Real Courtroom Breakdown. Our session opens with the case of Jacqueline Murray, a defendant who's been in and out of this courtroom more times than the judge can count. Today's hearing might look simple on paper, but behind every adjournment lies tension, frustration, and a life at a crossroads. Watch closely. This case sets the tone for everything that follows.
All right, record should reflect we've had a bench conference in this case. I'll give the adjournment rather than setting up the final settlement conference. Young lady, do me a favor. You've been up here before me, what, a gazillion times? That's a number. You've been here, right? Of what I know of all of your cases, listen to your attorney and go in that direction. That's going to be the best for you. I'm just going to tell you that. I mean,
Okay.
you can make up your own mind, but I think you're trying to do stuff that's just going to be disastrous for you. Keep going down the route that you're going down. You hear me? Okay.
Thank you.
The way you've been living your life, when you don't have people to kind of help you choose, that hasn't worked out too well.
I understand completely.
Right?
Yeah.
Because that's why you're before me in green right now.
I'm
So maybe listen to somebody else, do something. It may sound like hard work, but in the long run, it's going to be the best for you. And I wouldn't say that if I didn't think that's true. All right. I'll adjourn this out to December 17th, 2025.
thank you, Your Honor.
Thank you, Your Honor.
Jacqueline's hearing ends with yet another adjournment, but the judge's warning hits hard. Your choices will be disastrous. This is more than legal procedure. It's a wake-up call. Viewers, what do you think? Can tough judicial advice actually change someone's path, or does it often fall on deaf ears? As we shift to the next case, keep that question in mind.
Yes, man. Oh, yeah. I was going to come back. You knew that. Fine. I'll pass. Thank you. Court calls the case, People versus Alicia Allen.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Lauren Perny on behalf of Miss Allen. State your name for the record, please.
Alicia Allen.
All right, I have before me a plea form that indicates she's going to plead to an added count 2 of allowing an ineligible driver to operate a motor vehicle to 90-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right, very good. May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name.
Alicia Allen.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days incarceration, $100 fine plus court costs. Do you understand that?
Yes. Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You had signed an advice of rights form. Is that correct?
Yes.
Any question about any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Which one?
Probation.
Okay. Were you on probation at the time of this offense?
Yes.
All right. I do have to advise you then that this could be considered a violation of probation. If it is, the other court could sentence you to the maximum allowable under that other charge. You understand that?
Yes.
Still wish to plead guilty to this charge?
Yes.
Anybody promise you anything other than what's been stated here today on the
No.
record? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe you're guilty?
Yes.
All right. On the date of February 27, 2025, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes.
Counsel? Well, I do have to advise you that between the time of sentencing and the time of this plea, if you commit misconduct as defined in the Michigan court rules, court would not be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand
Yes.
that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Yeah.
And have I complied with the court rule?
Yes.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
Your Honor, regarding sentencing, if I may,
Can I stop you? No, go ahead.
Ms. Allen has been in custody for 38 days, correct? She is being held on a felony. Her next court date is before Judge Hamoud on December 1st. So she'll be in custody for at least another, what would that be, a week and a half, depending on what Judge Hamoud does. She's asking for a credit for time served sentence.
Why would I do that?
Because she's been in for a while. She resolved the case. She's probably
This moment is a great example of how plea deals actually work. Alicia isn't just saying guilty, she's trading one charge for another, avoiding a trial and accepting potential probation consequences. Pleas like this shape most American court cases. Ask yourself, if you were facing these stakes, would you take the deal or fight it out in trial?
Not gonna ask you that.
there.
All right. Fines and costs just go to the minimum $125. 38 days in jail, credit 38, sir.
Thank you.
Thank you.
Court, that's called the case of the people versus Latrell, Washington. Chief
Conrad
Justice.
Siller on behalf of Pittsfield Township.
People. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Washington. I'm not sure if Mr. Washington is present. I've reached out.
He is.
Oh,
Latrell, Washington,
Yes,
state your name.
Latrell Washington.
All right, you need to turn on your camera.
Yes.
Thank you. All right, what are we doing?
Your Honor, I have not had contact with Mr. Washington, so I've requested adjournment. The last hearing, I asked Mr. Washington to call and update his phone number. I'm not sure if he did that, and I'm calling the new phone number or the old phone number, so Mr. Washington, if you've gotten my calls, call me back. If not, call the public defender's office and update your contact
Oh
information.
yeah, I actually updated my number already.
When?
I updated my phone number after the last court date.
I'll adjourn December 3rd, 2025, 9 a.m. Bond continued. Make sure they've got your number
Okay.
and an email.
Okay.
All right. Otherwise, I'm going to make you come down here and they'll get it right from you.
Okay.
Thank you. Bond continued. Court calls the case People versus Sincere Godwin.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Godwin, excuse me. State your name for the record, please.
Sincere Godwin.
Thank you.
Your Honor, we're requesting an adjournment to view the media together. It's quite voluminous in this case. Mr. Godwin is being held on a Judge Conlon case. He sees Judge Conlon today. We believe he's going to be released today. If that matters to you for the next date.
December 3rd. Will that be enough time for you to get through all the media? You're indicating that it's a lot, you know.
In Sincere Godwin's case, You can feel the tension behind the calm voices, huge volumes of evidence, questions about release, and the uncertainty of what happens next. These moments remind us that real lives hang in the balance, not just legal files. When freedom depends on timelines and media review, every delay feels like a mountain. Would you stay patient or crumble under the weight?
Court recalls case People versus Rick Artuso.
Good morning again, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso, who's approaching.
Your name?
Rick Artuso? Your Honor, he's being sentenced in front of Judge Conlon on December 3rd at 1:30 p.m. I was going to ask for a date after that. Ms. Feltus, I believe, is in agreement with that.
That's correct, Your Honor. I don't know, for some reason he didn't take screening when he was in custody, so it got adjourned.
That's correct. They delayed the PSR for some reason, Your Honor. I don't know why.
December 17th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case of the People versus Joseph Griffin.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Griffin. Mr. Griffin, state your name for the record, please.
Joseph Burton Griffin, Your Honor.
The corporal gives tell you gotta move late.
No, he said.
Oh, no, I'm just kidding.
Why don't you go
I'm just saying how I saw. All right, no, go ahead.
I'm always in the way, so he gave me the right of way. Your Honor, this case is a drug paraphernalia case. It can be resolved if Mr. Griffin goes to treatment court, or not treatment court, drug treatment. He is hopefully going into drug treatment court, so we're asking for an adjournment for all that to take place. He has a couple cases set before you tomorrow on the PCC docket.
So are they trying to get him into felony drug court, or
Yes,
is that what?
Yeah.
Okay.
And he has releases on, I think, all of the other cases, and we'll get paperwork into you if
To release on this one.
Mr. Stiller agrees to release on this one as well.
I'll leave that to the court's discretion.
All right, thank you, Mr. Stiller.
Yes.
I'll adjourn the matter then to, well, has he started that process?
He's
No.
been accepted.
Oh, he has.
He's releasing also.
Yeah, he's been accepted into the program.
The felony drug treatment court.
Yes.
Okay. Okay.
He's also releasing.
Well, why don't I would do the 3rd, but you think we need the 17th to get everything wrapped up?
So the other complicating factor is he has a hold out of Wayne County. So that's got to be resolved before he can be released here. And obviously getting a hold of Wayne County can be difficult. So we're working on that. So I don't know if we'll get,
Why don't I do this? Let me make it December 17th, 2025, 9 a.m. If for whatever reason, everything gets worked out before then, contact Ms. Whiteling and we'll see if we can move it up on the docket for him. Fair enough.
that's good.
Okay,
Thank you.
thank you.
Now we enter one of the most emotionally layered cases of this session, Michael Atkins. Missed tests, alcohol violations, and the long fight for sobriety collide in a courtroom that's losing patience. But here's the question for you. Should courts show compassion for relapse or enforce strict accountability to protect the public? This case forces us to confront both sides.
In the pretrial, I suppose I asked for an adjournment. We're still in negotiations. And then there's a bond issue we should address as well.
Yeah.
So Mr. Adkins had some missed tests and saw a positive test for alcohol. Regarding the missed tests, we have been in touch with the place that he's been testing at in Flint. It seems like there's a little bit of delay in getting those results here. For example, there was a test on the 31st that when we were here on the 5th was said it was missed. He did test on the 31st. That result is now on that report that was sent by Community Corrections. So we're trying to work out.
Is the alcohol.
Yes. So we're trying to work out the kinks on the delay on getting the test to Community Corrections. So that's the first piece. The second piece is the positive alcohol test. I've had multiple conversations with Mr. Adkins regarding the positive alcohol. I think today he would like to admit to the violation with a bit of an explanation. He is, I think Mr. Adkins' road to sobriety is a pretty long and interesting one. He was addicted to opiates. As of last year, he relapsed, but before that, he was clean for about 3 years. He was completed inpatient treatment. He was working as a counselor at a sober living house here in Ann Arbor. He was a sponsor. He had worked through the steps multiple times. So he's very familiar with substance abuse addiction and the struggles and journey that can take a person on. He obviously admitted that they relapsed last year. Again, he struggles with opiates, and he's been clean from opiates now for over a year. Is getting back into that sobriety journey. He is going to AA weekly, and has moved from Ann Arbor, where his primary, problem was, to Flint, so he can. He's living with his brother, who's also 9 or 8 years sober, and re-enter that sober living lifestyle. So Mr. Adkins again admits to the violation. At the last court date, the court ordered him to come here to test in person. He did. The court ordered also for him to come in person today. He explained to me that his mom drove from Saginaw to Flint to pick him up and drop him off here. He's not trying to run from anything. He wants to take accountability for his actions. And I think he's doing that by admitting and trying to work through all of this. So I don't know if you want to say anything in addition to that, Mr. Adkins.
Your Honor, I take full responsibility of the positive alcohol test. I go to NA and AA meetings weekly in Flint. And I just want to not lose my job from incarceration, so I can continue to, pay for what I need to pay for, and so on and so forth.
He's willing to step up.
But has he taken the test? I mean, I got missed test and unable.
So
I don't have him testing.
There was an unable, I can't remember the dates off the top of my head.
November 12th.
Last week, he said he did go in the 13th.
As the judge examines the testing inconsistencies, the pressure rises. Defense argues delays and misunderstandings. Prosecution highlights patterns of danger. This is where courtroom reality hits hardest: facts versus explanations. And each missed test isn't just a mistake, it's evidence. Listeners, what matters more here? Intent, circumstance, or results? This moment shows how thin the line can be.
I think here in community, maybe the difference is here, the results are done immediately at community corrections, from my understanding. It seems like at this testing location in Flint, they are sending the tests out. And that's how we get the sample taken on the 13th and the result coming in on the 17th. And that's delaying those results getting to community corrections, which is delaying the results getting to us. So I think that's part of the issue of the delayed or the missed tests that are reflected on our reports. But then, like I said, there was one that said he was missed on the 31st, and now we'd have a result for that test. So it shows that he did test, although it is a positive test.
Based on the report, I trust defense counsel representations, of course, but based on the report that's before me, and I'm looking at, in 1 month, we've had one compliant test, which was November the 7th, which was a test that the defendant had 2 days of notice for. The court recalls on November the 5th, when we were here, the court ordered him to test by Friday. So he had 2 days to go to that test. I believe the science and what we're seeing here is a pattern of alcohol use and refusals or missed tests. If the court recalls at the time of arraignment, I let the court know that this was an OWI second offense. The prior is from 2019, which is not that long ago. And the defendant was found passed out behind the wheel of his vehicle, had to have 2 doses of Narcan to even come around at all, and was discovered to have 47 nanograms of cocaine in his blood. I'm extremely concerned for public safety. I think it's great that he's moved in with his brother, but clearly that's not working because he's been residing there since the pendency of this case, if I recall correctly. And we're having these tests that are showing ETG. We had 1 for THC and we're seeing non-compliance. The concern of the people at this time is public safety. And I'd ask the court at this moment, remand him for the bond violation. If the court is inclined to release them, I would request a scram tether. As well as the continued intensive supervision for drugs. That's also an issue here.
Anything else?
Anything else from you?
No, ma'am.
So here's part of the problem as I'm seeing it. And yes, I'm concerned about public safety, but I'm also concerned about this defendant. The thing is, you know what it takes to get yourself sober. And I'll just put it in a colloquial sense that what you're doing right now is you're just half stepping. And you know that. You know that you are not doing what it takes to get yourself there. And that's why things are coming out and working this way for you. You got to make up your mind, young man. If you want to do it, you know how to do it. You've done it. You just have to do it. This half process for you is not going to work. And you got to figure that out. But if you think that what I'm going to do while you're in the process of trying to figure that out is allow you to be out there, be in a position where you decide to get behind the wheel because you're doing whatever and then end up killing somebody, that's not going to happen. So what I'm going to do is I'm going to adjourn this to December 3rd, 2025, 9 a.m. He figure out in that time what he wants to do. But at this time, his bond is revoked. Defendant.
And with that powerful ruling revoking bond, this session ends on a decisive note. The judge's message is clear. Public safety comes first, and partial effort won't cut it. These hearings show us the human struggle behind every legal decision. If this real courtroom journey gave you insight, hit like, share, and subscribe. Stay tuned for more cases that reveal the truth behind the bench.